You are the investigator. You are the judge. And before this episode is over, you are going to have a theory. Hold on to it, because Part 2 is going to test it. Case number 2024-0892-CR, heard before the Meridian District Court, Callaway County, State of Hargrove. Two defendants stand before this court. The first, Officer Damon Reyes, badge number 4471, a 7-year veteran of the Callaway County Sheriff's Department. The second, Marcus Elijah Thorne, age 38, a private citizen with no prior criminal record. The charges are cross-filed. Officer Reyes faces 1 count of excessive force under color of law, a federal civil rights violation under 42 U.S.C. Section 1983, and 1 count of filing a false incident report, a Class D felony. Marcus Thorne faces 1 count of aggravated assault on a law enforcement officer, a Class B felony, carrying a maximum sentence of 15 years. Date of arraignment, March 3, 2024. The Honorable Clarence Dubois presiding. The court is now in session. It was 11:47 p.m. on a Friday in February. 29 degrees outside. Inside, Callaway Bar and Grill, warm, loud, and full. The kind of crowd that fills booths by 8 and starts getting complicated by 10. The bar smelled of fried food, spilled beer, and the particular closeness of too many people in a room with poor ventilation. At the far end of the bar, near the emergency exit, 2 men were arguing. Not the first argument of the night. The bartender, Rosa Gutierrez, had already separated them once, at approximately 11:20, over something she later described as a comment that went sideways. By 11:47, that comment had become something else entirely. At 11:49, Officer Damon Reyes walked through the front door, not in response to a call, by his own account in the incident report, stopping in after his shift for a meal. Partial uniform, department pants, department jacket, badge on his belt, firearms holstered. By 11:53, Marcus Thorne was on the floor, with a fractured orbital bone, a dislocated shoulder, and no clear memory of the 4 minutes in between. 4 minutes, 2 men, and a bar full of people who all saw something slightly different. This is where the case begins. This case lives at the intersection of 2 legal principles that rarely sit comfortably together: qualified immunity and equal protection under the law. Qualified immunity shields law enforcement officers from civil liability unless their conduct violates a clearly established constitutional right that any reasonable officer would have known. In plain terms, officers must be given reasonable latitude in split-second decisions. The law acknowledges that policing involves danger and uncertainty. But equal protection, guaranteed by the 14th Amendment, holds that no person shall be denied the same protection of the law afforded to any other. If an officer acts not in service of the law, but in service of a personal dispute, that protection collapses entirely. The question this case forces you to answer is this: was Officer Damon Reyes acting as a law enforcement officer that night, or was he acting as a man with a grievance and a badge? Because the law treats those 2 things very differently. And the evidence, as you are about to discover, does not answer that question cleanly. Nothing in this case is clean. Damon Reyes, age 34, born and raised in Callaway County, joined the Sheriff's Department at 27 after 2 years of community college and a period working construction with his father's crew. Graduated from the Hargrove State Police Academy in the top third of his class. His early performance reviews are consistent across the board: thorough, responsive, physically capable. His third-year supervisor described him as someone who takes his authority seriously. In 7 years, he has received 2 commendations, one for pulling a driver from a burning vehicle on Route 9 in 2020, one for de-escalating a domestic disturbance his supervisor noted could have ended very differently. He has also received 2 formal complaints. The first, filed in 2021, alleged unnecessary force during a traffic stop, investigated, closed with no finding of misconduct. The second, 8 months before the incident at Callaway Bar, alleged intimidating behavior during a noise ordinance response. That complaint was still in internal review on the night of February 9, 2024. Reyes is single. He lives 12 minutes from Callaway Bar. Rosa Gutierrez confirmed he's a regular, comes in approximately once a week. She also confirmed, when pressed during the investigation, that she had seen Reyes and Marcus Thorne in the same room before. She described the prior interaction as tense but quiet. That detail does not appear anywhere in Reyes's incident report. Marcus Elijah Thorne, age 38, born in the Meridian District of Callaway County. Completed a certificate in HVAC installation at Hargrove Technical Institute in 2007. Has worked for the same mechanical contracting firm, Breyer Systems, for 11 years. His supervisor calls him dependable, skilled, and well-liked by every crew he has worked with. Thorne is the father of 2 daughters, ages 9 and 12, shares custody. His mother submitted a character statement to the court, describing him as an active and present father. On Saturday mornings, he coaches youth basketball at the Meridian Community Center. What Thorne does have, the thing that connects him to this case before the night of February 9th, is a history with Officer Damon Reyes that goes back 14 months. In December 2022, Reyes responded to a noise complaint at a gathering at Thorne's apartment. By Thorne's account, the interaction became personal. By Reyes's account, Thorne was uncooperative. No arrest was made, no report beyond the standard call log. But 3 people who attended that gathering were interviewed after the Callaway Bar incident. All 3 said the same thing independently. Reyes and Thorne knew each other by name before December 2022. They simply cannot agree how. That is the thread that runs through this entire case. Pull it carefully. 2 days before the incident, Marcus Thorne received a text from his coworker Jerome Pickett, inviting him to Callaway Bar on Friday night. Thorne replied at 6:22 p.m., "Yeah, I'll be there. Needed after this week." This message establishes one thing the defense will rely on heavily. Thorne's presence at Callaway Bar that night was spontaneous and social. He was not there looking for anything except a drink with a friend. Rosa Gutierrez began her shift at 5. She served Thorne his first drink around 10. By her count, he had 3 beers over the course of the evening, moderate pace for a Friday. She observed him with Jerome Pickett and 2 other men. No aggression, no altercations. The first verbal exchange, at 11:20, was brief. She stepped between them. It ended. The second escalation began around 11:45. The other party, a regular named Gary Sessoms. At 11:48, Sessoms left the bar. 1 minute later, Officer Reyes walked in. Sessoms left, then Reyes arrived. That sequence is not disputed by anyone. 11 minutes before Reyes entered Callaway Bar, his personal mobile phone received a 2-minute call. The number that called him is registered to Gary Sessoms, the man who had been arguing with Thorne, the man who left the bar 1 minute before Reyes arrived. Reyes's incident report states he entered Callaway Bar after his shift for a meal. It does not mention the phone call. It does not mention Sessoms. Gary Sessoms has since invoked his Fifth Amendment right against self-incrimination. He will not testify. The content of that 2-minute call will never be entered into evidence. What you do with its existence, that is your first decision as an investigator.
Reyes's department-issued body camera activated when he entered. Hargrove Sheriff's Department policy requires officers in partial uniform to activate cameras upon entering any public space. The footage is running. The prosecution's forensic video analyst testified that within 4 seconds of entering, Reyes's gaze moves directly to the far end of the bar, to Tamarcus Thorne. Not to the bartender, not to the room, straight to Thorne. The defense disputes this. They argue the camera angle makes precise gaze direction impossible to determine. Watch that 4 seconds carefully when you picture it. 4 seconds in a crowded bar. Where does your eye go when you walk through a door? Jerome Pickett was standing 6 feet from Thorne when Reyes approached. Pickett states that Reyes did not identify himself as a law enforcement officer. He states that Reyes's first words were, "You're still doing this, Marcus." Not, "Is there a problem here?" Not, "I need everyone to calm down." "You're still doing this, Marcus." First name, present tense, personal. Thorne's response, according to Pickett, "I'm not doing anything, I'm having a drink." What happened in the 90 seconds after that is where every account in this case breaks apart. At 11:52:47, the body camera footage goes dark. Not corrupted, not deleted. The camera appears to have been rotated inward toward Reyes's own torso, producing 14 seconds of darkness and muffled audio. The department's internal affairs unit characterized this as consistent with physical movement during a struggle. The prosecution's digital forensics expert testified that the camera's gyroscope data shows no significant rotational movement during those 14 seconds. The camera was still for 14 seconds, while Marcus Thorne was put on the floor. Then the footage resumes. On February 22nd, 13 days after the incident, a patron named Devin Achebe reviewed his personal phone camera roll. He had been recording a casual video that night, something for a group chat, capturing the bar atmosphere. He did not realize until 2 weeks later that his camera, angled toward the emergency exit corridor, had captured something in the background. 11 seconds of footage, poor lighting, a bar stool partially blocking the frame. 2 figures, one on the ground, one standing. The standing figure's arm is raised. The prosecution's analyst says the arm is in a downward striking position. The defense's analyst says the figure is reaching down, restraining, possibly assisting. 11 seconds, one arm. 2 completely different interpretations from 2 qualified analysts. A Devin Achebe came forward voluntarily. He has no connection to either party. He simply looked at his camera roll 2 weeks later and understood what he might have. That footage is in evidence. It has not resolved this case. It has made it harder. And in a case this close, that may be the most significant thing it does. You have now seen the scene, the people, the timeline, and the evidence that exists before a single legal argument has been made. Here is what we need from you right now, before Part 2 drops. Tell us in the comments, based solely on what you have seen in this episode, where is your instinct pointing? Not your verdict, your instinct. Do you think Officer Reyes went to that bar with a purpose? Or do you think Marcus Thorne made a decision in those 90 seconds that started everything? And what is the single piece of information from this episode that is sitting most uncomfortably in your mind right now? Tell us where you are watching from, your city, your state, your country, because we are tracking responses globally, and when Part 2 drops, we are going to show you exactly how your location influenced your instinct. Viewers from different places are reading the same evidence differently, and that tells us something important about how justice is perceived around the world. Your responses are not just comments, they are data. They are going to shape how we open Part 2. The most cited piece of evidence from your responses will be the first thing we revisit when the legal arguments begin. So look at those 14 seconds of darkness one more time. Look at that phone call from Sessoms that nobody will explain. Look at Devin Achebe's 11 seconds of poor light and one raised arm. Form your theory. Hold it firmly. Part 2 is going to test it.